Hello, and welcome to the Office of the Patriot. In this office, I try to make sense out of the nonsense of the progressive left. If you are a subscriber, thank you for your continued viewership. It is appreciated. If you are a returning viewer, please take a moment to hit the subscribe button so you don't miss any future presentations. And if this is your first time to my channel, well, congratulations on finding it. It's usually buried in obscurity by the YouTube algorithm. However, I hope you find the content worth coming back for. My name is Myron Ybarra, and I'm your host. In episode 43 of Office of the Patriot, I discussed the multifaceted attack on the Second Amendment by liberal progressive Democrats. Today's presentation is the result of an experience I had last week that ties into that episode. As many of you know, I am a retired California peace officer. As such, I am authorized under law to carry a concealed firearm per House Resolution Bill 218. Also known as H.R. 218 or LEOSA, which is an acronym for Law Enforcement Officers Safety Act. LEOSA is federal law that was enacted in 2004 that allows qualified active and retired law enforcement to carry concealed firearms in any jurisdiction of the United States, regardless of state or local law, with certain exceptions. These active and retired peace officers must be firearm qualified pursuant to their home state peace officer standards and training, also known as POST requirements. And for the most part, LEOSA does work as intended. It allows for active and retired law enforcement to carry concealed firearms in public places throughout the United States. However, there's been a recent trend by liberal progressive Democrats, more accurately described as socialists, to remove Second Amendment protections that are enshrined in our Constitution, and even peace officers are not immune. But before I get into this topic any further, I would like to get your take. Do you believe that the business owner has the right to prohibit firearms on his or her property, thereby depriving lawful citizens of their ability to defend themselves? Please take a moment to comment below. As I said, this presentation is a result of an experience I had while carrying my firearm concealed. And for complete transparency, I'm usually carrying about 90% of the time when I'm outside of my home. The other 10% are in situations where I know my backside is covered by other means. On this day, I was invited to a local soccer match by a friend who's also a retired peace officer. I've never been to a soccer match, so I accepted the invite. I've been to a number of sporting events, however, and I'm usually armed when I go. And when I go through security, I advise them of my status as a retired peace officer, I show them my credentials, and I am allowed entry. Occasionally, I'll even get a thank you for your service greeting. However, on that day, both didn't happen. I was advised by security that I would not be allowed to maintain my firearm if I wanted to come in and watch the game, even with my credentials. The security manager went as far as advising me that the Las Vegas Metro police officers, who were standing about 40 feet away, are not allowed inside the venue while armed unless they are dealing with an active violation of law. My eyes just about popped out of my damn head. After pleading my case and realizing I was getting nowhere, I went to confirm the security manager's claim with the officers. And sure enough, the sergeant who was on duty confirmed what I was told. The officers provide security outside of the venue, but do not go in unless they are going to conduct an arrest, investigate a crime, or secure an active crime scene. Why would this gun-free zone be allowed, even for peace officers? Well, I was advised that the owner of the venue prohibits firearms on their property. Unfortunately, this trend has taken off like wildfire in many liberal-run cities, like Las Vegas. When liberal politicians can't remove 2A protections through legislation, they encourage liberal business owners to do it for them. Now, I'm sure there are going to be a few of you who are going to respond to this comment by reminding me of my position regarding private property. And to be clear, I do believe private property is sacrosanct, with very few exceptions. And yes, there are legitimate exceptions that I'll explain with an example. As a homeowner, you have absolute control over who you allow into your home, short of a legally obtained search warrant. If you don't want to have a person who's part of a federally protected group, like, say, a person with a disability or a person of Hispanic descent, that is your right. However, if you own a business that's open to the public, even though that business is considered your property, under law, you cannot exclude a person based on a federally protected group. that's a violation of law. So, how are businesses able to prohibit firearms on their property? The legal term for this 2A infringement is an opt-out statute. This essentially allows businesses to opt out of state gun policies and create a gun-free zone within their own business. In Democrat-run cities and states, privately owned gun-free zones have the same force and effect as government gun-free zones that prohibit firearms on school grounds or in the post office and in jails and prisons. Fortunately, there are a few states who recognize this trend and have taken steps to fix it, and Arizona is one such state. Arizona has increased the liability for businesses who adopt a gun-free zone by prohibiting customers from legally carrying their firearms while conducting business on their property. If the business owner removes a person's right to carry a firearm while on their premises, and that person suffers injury that they may have been able to prevent or reduce with a firearm, then that business could be liable for damages the injured customer sustains. And in my humble opinion, that's exactly how it should be. With the Second Amendment, our framers codified the right of a person to use a firearm to defend themselves. So then another person should not be able to remove that right under the pretense of safety. What's the basis of my argument? Well, it's in the beginning of the Declaration of Independence. All Americans are endowed by their Creator with certain inalienable rights that are, among these, life, liberty, and the pursuit of happiness. One citizen should not have the right to remove a liberty, and in this case, the legal possession of a firearm, from another. And as such, a person who legally possesses a firearm in public should be treated as a federally protected group. And businesses should or are prohibited from discriminating against protected groups. But until this happens, it will be left up to us, pro-2A American citizens, to combat this infringement. And we do that by taking our money to businesses that don't have gun-free zones, and by holding businesses civilly accountable if or when the unthinkable occurs. Well, that concludes this episode of Office of the Patriot. If you enjoyed what was presented, please take the time to like, subscribe, and share my channel on your social media. It is appreciated. And as always, have a great day and stay safe out there.